Yeah. We did May 24th transfer. Yes, we were not transfer.
You said the 24th?
Yeah, it was May 24th. May 24th.
What's it plan? Notice of transfer 5518.
Okay, this is
And Mr. Ambrose has it.
Mr. Ambrose, do you have I got a letter from your client saying that you don't have a May 24th transfer.
I have it now. I provided him with it.
I'm sitting upstairs.
Okay, that's fine.
Yeah, I met with him about a week ago.
Okay, very good. That's wonderful. Okay, great. All right.
Yeah, he's had a chance to review it.
Okay, good. Let's bring him out. Ready?
The recall?
Yes.
Case number 138320, the people versus Robert Bashara.
And once again, you're on John Boy Call for the people.
Ronald Ambrose appearing on behalf of Mr. Bashara.
Good morning. You may be seated. The court had an opportunity to receive a letter addressed to the presiding judge, the chief judge, Judge Colombo, about some transcripts that were not received. And you indicated that you have them.
Yeah,
Mr.
I have those
Ambrose.
transcripts. I provided Mr. Bashara with a copy of the May 24th transcript.
Okay. Do you have those, Mr. Bashara?
I think I met with him on Tuesday and I provided a
You
copy.
do have them?
I do have them now. I didn't have them prior to
When you sent the letter?
our
Okay.
meeting.
Okay, very good.
Your Honor, I'm sorry. Can you speak up a little? I apologize.
No, the letter that you sent Judge Colombo, I'm in receipt where I was concerned that you didn't have the transcripts, but you do have them now.
I do have them now, and the only reason I sent those to him, Your Honor, was because he sent me and I had it, a listing of all the transcripts, and two of them were not marked as ordered. That's why I requested those from him.
From
I should
who?
have sent that to your court, actually.
From Mr. Ambrose?
No, from Judge Colombo.
Oh, Judge Colombo had correspondence with you?
He sent them to prison, yes. Would you like to see what he sent me?
Oh, I would.
Okay. Give me a
He's
moment.
probably referring to the order,
Yes.
order of the transcripts with the stamp of Judge Colombo's signature on it.
Yes. It's going to take me a moment to find it,
Take your
but
time.
I have it here. Here. I have page 2, and I got to find page 1. Here it is.
Deputy Dede, I'm sorry. Could you get that book from? Is Tommy here? Yes. Oh, sorry.
Yeah, it's right
Could you get those?
No.
Dede, get them.
I just came up here wrong.
Here, Kelly.
That's the only reason I responded to him, Your Honor.
Okay, no problem. Madam Clerk, excuse me, I'm sorry, Madam. I'm ready to proceed at this time. Okay, Mr. Ambrose, the court has set aside a substantial part of this day for you to make your arguments, as well as rebuttal by the prosecution, and then the court is going to rule. You may proceed.
Can I reserve like 5 minutes for a rebuttal?
You may.
All right, appreciate it.
Did I give you a time limit?
I think you said 40 minutes.
That's correct. You may proceed.
So
You take as much of that time as you, and then I'll let you know when you get to that 5-minute time.
I appreciate it. Thank you, Your Honor.
You may proceed.
And I do appreciate the court indulgence in many respects. There were a lot of things I wanted to get into evidence, and some wasn't allowed, but I do appreciate the ability. Lillian Diallo and Michael McCarthy were the trial attorneys, and Ms. Diallo was appointed on the case in March of 2014, and by that time the case had been proceeding for a full year. About a month afterwards, Michael McCarthy was appointed to assist Ms. Diallo. Prior to even the case being filed, there was a 15-month investigation. There were over 300 witnesses that were interviewed by the police, and 70 subpoenas and search warrants. Now, one of the problems in the case at the very start is the inability of the defense team to contact many of these witnesses. There are like I said, 300 witnesses, but none of the contact information was provided to the investigators. And what they had to do was utilize their own resources to try to interview these potential people to find out whether or not they had useful information. And according to Joseph Bruce, who has a history with the Detroit Police Department and as an investigator, and Hank Glaspie, who also has a very stellar career with the FBI, they were only able to contact, of the 300 witnesses, only at most 11 of the 300. And that's because they were just not given the contact information. Had they been given that contact information and interviewed everybody that they wanted to, the case, I believe, would have traveled a different road. I've been on the case for over a year now, and there are still things I am looking for, and things I have never seen before, things that are referenced, and I've been given, a digital discovery, but it's not formatted in any way, and there's just no way that these attorneys, with 6 months of prep time, handling their own cases as well, could have gotten up to speed in enough time to do an effective job. The preliminary examination transcript alone is 900 pages. So to review everything, handle their own cases, and get up to speed with no contact information from any of the witnesses, and in essence the investigators being handicapped, it was just no way that my client could have gotten a fair trial. There were videos that were not obtained that prevented the defense from preparing the case. In particular, outside of the McDonald's, to see how Joseph Gentz arrived at that McDonald's. It's our firm belief that more likely than not he didn't walk there, that he got dropped off there. It's an important aspect in terms of the timeline of the case. Another issue was outside of Dillon's bar, where that video was never obtained. that could have certainly helped the defense team in determining that Joseph Gens and what he was saying when this offense occurred, my client was nowhere to be found at the house, 552 Middlesex. He was at the Hard Luck Lounge, and there are plenty of witnesses that had saw him there. We have, and these witnesses, it's indisputable. Michael Carmody, who testified at trial, testified without a doubt that my client was there 7 o'clock. They had their meeting there. Well, what does Joseph Gens say in his testimony in May? He says from 6 o'clock to 7:30, my client was there, without a doubt. And he knows that because he saw it on the Mercedes-Benz clock, inside clock. On that basis alone, Joseph Gens cannot be believed. But there is so much more to this scenario that Joseph Gens wants everybody to believe. Joseph Bruce testifies that he was able to review the video of Joseph Gens in his initial interviews with the police in January 31st, 2012 and February 1st, 2012. In there, Joseph Gens mentions, without a doubt, that he alleges my client had this semi-automatic gun. Well, that was not the gun that was portrayed in front of the trial. In front of the trial, it was an antique revolver, and that's Joseph Bruce testified as to that. With regard to Joseph Bruce said the clothing, the disregard of the clothing was a major issue. Jane Bashara's clothing. After the autopsy, it was not retained by the police. There is a wealth of information that could be garnered if that clothing was retained, and it was not. It was discarded, and I don't know what happened with the clothing, but it was never tested. Joseph Bruce also states that the focus from the beginning was on Robert Bashara and no one else. But there were others that Joseph Bruce wanted to contact, wasn't able to. One person being J.J. McKee. J.J. McKee is the person who Joseph Gens, at the time of, on the night of the murder, is seen with Joseph Gens. They're together at the bar, and there is no interview done with J.J. McKee, not by the prosecution and not by the defense team. And this is a situation where J.J. McKee was contacted by the prosecution, but they alleged that he was not cooperative. Well, we have a situation where there are investigative subpoenas for many, many people, and none was done on J.J. McKee. Not one interview. They didn't require him to come down and make any type of statement under oath. And that is a major aspect of the case. There's a duty upon the police, or upon the prosecution, to preserve evidence and to provide that evidence to the defense. It wasn't done in this case, in particular with regard to Jane Bashara's clothing. So under ineffective assistance of counsel, there's a duty to make reasonable investigation. And that investigation includes the obligation to investigate all witnesses who may have information concerning the client's guilt or innocence. And simply put, it just wasn't done in this case. And it's my firm belief that the time that the attorneys had was a major aspect of that. It's just not enough time to fully prepare, considering that there was no contact information from the prosecutor's office, no contact information on the witness list. They were handicapped from the get-go. So I have cited Strickland in my brief. I also want to reiterate the Arizona versus Youngblood regarding the prosecution or the police's responsibility to possess and not destroy potentially useful evidence. In this case, the evidence was certainly apparent when you have a case of murder and the government destroys the evidence of the clothing.
Okay, now that's not accurate in this case. It wasn't the government that destroyed the clothing. Based on the testimony that was elicited here, that they failed to pick up the clothing as a result pursuant to more policy, because the clothing wasn't picked up, then it was discarded. So it wasn't as though there was a deliberate attempt to hinder an investigation by willfully destroying evidence. But go ahead.
All right, and I do have, and it's on another case, and I prepared it just for, I have it, if I can refer to it on the screen.
Go ahead.
And it involves the, this is on People versus Sammy Pettis.
Well, Your Honor, I'm going to object because we're limited on the evidence that was presented at this hearing.
No, I think that what he's doing is addressing the point I brought up. I got this. Go ahead. What about Sammy Pettis?
Yeah. And there's testimony in that case from the medical examiner's office that the policy of the office is to document in the presence of any clothing that came with the body or came with the body bag. You bag this clothing in a brown bag, label it, and hand it over to the law enforcement officers and investigators. And that's the policy, but the clothing in our case wasn't preserved. So, that's certainly a big issue, in my client at least.
But it's a big issue, wouldn't you say, for both sides? Neither you nor the prosecution had the benefit of that evidence.
It's important. That's true. It's even more so in our. I would have.
But go ahead.
All right, but I have,
Very good. Just keep going.
There's this, J.J. McKee is a major person in this case, and it just leaves one to wonder what happened with that clothing and why wasn't it examined. And DNA evidence, if it had shown another source, certainly that would have been exculpatory towards my client, and it just wasn't done. I made mention in the my motion regarding the venue and the jury selection, and this was a much publicized case from the very beginning, and never was there a thought of potentially changing venue. I had done a sample of other jurisdictions, such as media reports and the local newspapers there. They just did not cover the Bashara case like it was done here in the Metro Detroit area. I can present that to the court. I can, show you the news clippings if you'd like.
Off the record. Okay. I'm listening. And so you were saying that there were other counties?
Yeah, and I did, just a general, I took papers from the first day of jury selection, first day of trial, and when the jury was came back with a verdict. And, it was front page in the Detroit Free Press. In the other jurisdictions, I checked out Midland and Menominee. There's no such coverage.
Can I ask you a question?
Yes.
Now, as I can recall, it was a live stream. Did you check to see whether or not they were able, through the internet, to pick up the Detroit news so that they could see it live stream? It was amazing, because I even heard people from all across the country were saying that they were able to see this. And I don't know if they subscribe to the Detroit News, but I do know that the local newspaper, as well as the media, did live streaming. So how can we prevent someone from, or know that they were in fact live streamed?
Well, I don't think the saturation of this case reached other areas of the state.
And your basis is what, sir?
Well, I could just...
Will it reach People magazine?
Yeah.
But go ahead.
Okay. I think the local area had more, yeah, absolutely, more interest in the case, and it made front page rather than being stuck in, page 5.
But you know that it was live streamed.
Yeah.
So if it's live stream, that means anyone with a computer, anywhere in the world, can watch what we're doing, or watch the trial.
Right. But a person in Menominee, I don't think, is more likely than a person in the Detroit area to actually have an interest in the case.
Okay.
That's my point.
Okay, go ahead.
The jury selection process, I have examples from other cases where sequestering the jurors in terms of their questioning during voir dire, I think was a procedure that could have been used to protect my client's rights. There were many jurors that came out flat out. I think I counted at least 9 that said that he was either guilty or that they had a bias in favor of the prosecution. Now, granted, those jurors were not on the jury, but they expressed their views in front of the other juror members. And that's the...
Can I ask you a question?
Yes.
Is that uncommon? Is that uncommon in every case of some magnitude, or even every murder, to sequester jurors and have them to come in one by one? Or are you saying that because of the media attention that somehow this should have been done?
Well, I have up on the screen, this one's...
Just say it. I don't need to look at the screen.
All right. It's just in the time that I've been on this case, I have 2 cases that they questioned the jurors individually if they had any type of contact or information from the media. And that's one out of Kalamazoo, and the other one I believe is Van Buren County.
Okay, very good. It was done there, but that does not mean that this court is bound to do it in that fashion. And did you check to see if there were any cases that used questionnaires?
I did not.
Okay.
And that's, quite frankly, it's another thing that I've been, I have this video or this technical digital discovery. I've been trying forever to find these questionnaires. Still can't. Contacted both attorneys.
You could have asked me. I have a questionnaire.
Okay.
But anyway, go ahead. I might give you a little extra time to look at them. So, go ahead.
All right. But it's just a way to safeguard a defendant's, rights with the sequestering during voir dire of individual juror members. And I'm going to move into, it's an issue that I raised in the brief, the jury instruction on reasonable doubt. The jury had sent out a question regarding what was reasonable doubt. I'm going to rely on my brief on that. I don't think it's necessary for me to add anything to that. Another issue that we raised in the motion for a new trial and the supplemental motion is the right to confront witnesses and newly discovered evidence. I mean, Joseph Gentz, I just don't see how anybody could believe his fantastic story of how this alleged case came about. You know, we have his testimony, and I mentioned it earlier, but his testimony, plain and simple, says that from 6 o'clock to 7:30, my client is with him, without a doubt. You know, simply on this basis alone, the court could grant a new trial, because there's indisputable evidence from multiple sources that my client was at the Hard Luck Lounge at 7 o'clock. And it's not only Michael Carmody who testifies as to that, but there are also other witnesses and other statements that is just indisputable. You have Carol Ponderzak and Michael Ponderzak, who provided statements to the police saying, yeah, they saw Mr. Bashara walk into the Hard Luck Lounge at 7 o'clock, and how do we know this? Well, on the way home, Carol Ponderzak, she calls her husband, and she's halfway home. Well, the next day, the story gets out that Jane Bashara was killed, and Michael Ponderzak states, make sure that you keep a screenshot of what time you called me, because you said you were halfway home. Halfway home was at 7:12. And so that's another two witnesses that would verify that my client is at the Hard Luck Lounge at 7 o'clock. So, there are so many things that I'd like to address with regard to Joseph Gentz, and I hope the court,
You take your time.
if the court will indulge me.
I'm indulging.
Okay, because these interviews that he had done with the police are so instructive as to how.
Again, Your Honor, none of that came in either at trial or in this hearing about any of the statements he made to the police. So I would
Yes,
object.
it did as to the time.
As to the time, yes, but
So let's
looking at what Mr. Ambrose has put up on the screen prior to this hearing.
All right, very good. Just overrule. Go ahead now. What'd you say, Mr. Ambrose?
All right. Well, you know, if we want to go to the time, then
Just go for it.
Your Honor, he's going to play something that hasn't been entered into evidence. Now, wait, stop! Sir,
Hold on for a minute.
sir.
Mr.
Hold on.
Ambrose, you can't do
Okay.
that now. Go ahead.
just didn't.
Okay, now, there was testimony as to the time, and I have no problem with that coming in, but this never came in at trial, never came in this hearing, and it is just inappropriate to be playing this in front of the cameras, in front of this court, when it's not even evidence for this court to
Very
consider.
good. Now, you can't do that. Nice try, on.
Well, it does go directly to the time.
It doesn't, this wasn't admitted.
You can't go into it being admitted. Well, go ahead. But you did, but the transcript revealed that you asked the question, didn't you say that it occurred about 7? And Mr. Gentz said, no, I was referring to something else. That did come out, but
Right.
this did not.
All right, but and I guess I'm getting a little redundant in terms of the time. I just wanted to hammer the point home that in multiple cases, in multiple videos, clips here, he just mentions the time, but he did testify without a doubt. My client is there from 6 o'clock until 7:30, and we know that was not the case. I do want to, part of my presentation today was to get into some of these video clips.
Well, you can only get into things that was actually admitted, okay? And you know that, so.
Well, and if I can...
And I gave you latitude. This hearing is going on for a year.
No, I understand that, but, I did make an objection, I'll renew it now, in terms of, I wanted a lot of what Joseph Gentz had said in these interviews with the police, because it is imperative, and I think, just to show the court, that his story doesn't make sense with the indisputable facts of the case whatsoever.
But I got a question for you, Mr. Ambrose. In your motion that you filed, you said the defendant was denied the right to scrutinize the statements of Joe Gentz to the police. His out-of-court statements implicating the defendant can be seen as nothing more than a backdoor way of presenting such evidence to the jury without the scrutiny of cross-examination. You then go on to say that when you got the information, the voicemail from an investigator, from Mr. Leonard Accardo, that you had indisputable proof of the innocence of your client. And I'm just wondering, you filed that supplemental affidavit. You are the one that said that this was newly discovered evidence. And then after Mr. Gentz testified, now you want to say, oh, that's okay, we don't want him. It's like you almost want to unring the veil. That motion that you filed based on Mr. Gentz's recantation of what actually occurred, you said was indisputable proof of the innocence of your client. But go ahead.
And on that basis alone, that affidavit alone, is indisputable evidence of my client's innocence.
Okay. But you didn't take the opportunity, and I was just somewhat wondering, something that Mr. Bashara asked in his belief that the lawyers didn't do a good job was, how do you ask a question, never ask a question that you don't know the answer to? And he was perplexed. Well, you have to be a mind reader to know that. But basically what that's saying is that you never get into an area you don't know anything about. Along the same lines, I was just kind of wondering, why didn't you ever interview a witness before they took the stand to see what they were going to say before you filed an affidavit? Couldn't you have done that?
If I would have interviewed...
Mr. Gentz. Because what he said was totally inconsistent with that affidavit.
And I'll put that on myself, Your Honor.
But there was an opportunity.
And if I'm accused by my client of ineffective assistance of appellate counsel, I'll fall on that sword. Because without it was suggested to me. And my mind frame at that point was, well, he has an attorney. It'd be not appropriate for me to visit him.
But did you knew that he had an attorney, right?
Well,
Wait a minute, hold on for a minute. This is back in December.
Right.
And you knew if you wanted to, and with this affidavit armed with it, that you could have contacted Mr. Holland and or this court to allow for Mr. Gentz to potentially be interviewed. That was a possibility before you filed this affidavit as seeking a new trial on based on newly discovered evidence. You had an opportunity to do that, didn't you?
I had an opportunity to do that.
But you selected not to, didn't you?
An affidavit, I did. With that affidavit, he's going in front of a notary public, raising his hand, and saying that this information in this affidavit is true.
But now, after he testified, he's a liar, he don't know nothing, he's inconsistent, what he said in the interviews didn't right. It's almost like you want to discredit the star that you thought was going to make the winning touchdown. Now you want him eliminated from the game.
I would be dancing in the end zone, pretty much, if he would have testified consistent with his affidavit. But he didn't. So
But you knew that this was a man who made inconsistencies. all through, because that's what I thought you was trying to get to with the video a minute ago, about how he was saying different things in his interview with the police. This was someone who, wouldn't it be fair to say, might have been considered a loose cannon? That's what I think that Ms. Diallo said, that maybe we need to double check his accuracy before we put him up on the stand. Do you think you could have done that?
Well, you know, that affidavit is, from my perspective, just changes everything. And I think the court, based upon that affidavit alone, can order a new trial. Because I have case law regarding, and I'll give it to the court. I made copies for the prosecution as well. But an affidavit of a recanting witness can be used to impeach him. And if this case is ever retried, that's a written statement. It's not only a written statement, it's somebody going in front of a notary public and swearing to the truth of it. And, you know, that is, I had to get to your question before, if you would have just sent me a letter stating, you know, and signed Joseph Gantz, and without the notary, then I think further investigation I would have conducted. This one, I didn't feel the need to, because this is it. You know, he goes in front of the notary, he's swearing to the truth of it.
Let me ask you a question. When you go see Mr. Bartonelli,
yes,
who is the person who prepares the affidavit, he basically want to talk to you about his case. Didn't you kind of think that maybe this was kind of a bait to get you involved to come to see him so that you could talk about his case with him?
Not at all.
Okay.
No, as an officer of the court, not at all. I wanted...
And let me just ask this one other question. Did you find it interesting that Mr. Bartonelli, who is also a prisoner at the Macomb Correctional Facility, had an investigator? Was that kind of odd to you?
No.
Okay.
I mean,
Let me ask you a question. You've been practicing law a couple of years, and you're an excellent lawyer. Sometimes isn't it somewhat challenging to trust witnesses who give you important information and incarcerated, that sometimes they can have another objective?
And I agree with that. And I would have the same feeling as well. But I met with him in person.
Mr. Bartonelli?
Yes. And in our meeting with him, it was very compelling. And he not only, I mean, he starts the meeting off with, you know, he's a jailhouse lawyer. I mean, he's a paralegal, he has his certificate, but he knows his stuff. So, you know, he provide, and the reason I get to that is he provided me with letters from very influential attorneys that he has worked with or had cases with. So you know, after seeing these letters, and I felt
But
confident.
based on that, if anybody knew what to say and how to say it to get your attention, it would be somebody like a jailhouse lawyer, wouldn't it? Because that's what he's skilled in doing. Did you ever consider his credibility at all?
I did.
Because as you say, he was a jailhouse lawyer. He wasn't a barred attorney.
No, you're right.
But go ahead.
And let's face it, you know, his testimony, Carlo Bartonelli has really nothing to gain. He never wanted to be here. He has serious medical issues that he did not want to leave, unless it's for his own freedom, but he didn't want to leave the confines of the Macomb Correctional Facility because it's just not safe for him. So, you know, but he testified, you know, as to the process that he used to make sure that what was typed up in this affidavit was accurate, that he didn't want to be a part of anybody committing perjury. And so that's what his testimony was. He would test Joseph Gens in terms of, you know, making intentional misstatements to him so that Joseph Gens could correct him. And, you know, that...
So basically, he just did this just to be a good Samaritan, to see that justice was served, and that someone who had been convicted wrongfully should be able to have a new trial. That was his only interest in this whole matter. That's what your understanding is?
I think he's a person that believes in the justice system, you know, that justice can be obtained, and he wasn't going to be a part of anything that was untrue.
Of course.
You know, that's...
Go ahead.
And, yeah. And that, as I said, Your Honor, I would not have... In my meeting with, and I'll just tell you a brief little story. In my meeting with Carlo Bartonelli, I wanted somebody else there with me to verify that I was... and so Leonard Arcardo was the person who called me, you know, saying that...
Who, for the record, was Mr. Bartonelli's private investigator.
That's correct. He was asked by Bartonelli, find out who Bashara's attorney is. And so I get that phone call, you know, in early December. And, you know, at that point, he didn't tell Arcardo the contents of what information he had. He just said there is valuable information. So I sent Bartonelli a letter saying, hey, can you let me know what it's all about? And we exchanged a couple of letters, and I wanted on that day I met with Bartonelli, I wanted Arcardo there. So we set up a time, I think it was December 28th, it was a Monday, like 3 o'clock, and we're going to meet. Well, on that day, just a horrible weather conditions. And Arcardo's coming up from the northern part of the state to meet me there. He gets there first, and they tell him, there's no meetings today due to the weather. And I came about 15 minutes later, and I said, and by that time he had left. Okay. But I wanted him there just to verify, you know, this is somebody that is telling me this is what's in the affidavit. You know, I basically wanted a witness. I wanted Arcardo there to witness that I met with him, because I didn't want to be in this situation having to explain to the court, you know, my dealings with Bartonelli. But, I mean, it is what it is.
In fact, you still didn't elect to take it upon yourself just to double check that everything in that affidavit was true. Basically, you relied on the fact that it was a sworn statement. So it was your belief, from my understanding, of Joe Gens, that because it was a sworn statement made by him to a notary, there was no reason to make sure that what he said was true.
I don't know any better way to go about it. It's in writing, it's in front of a notary. It's a sworn statement, and, you know, I have case law. He's presumed, you know, to know the contents of it.
And people who take oaths in court all the time lie.
Understood.
That's why they have a crime called perjury. Yeah. But go ahead.
And at this point, you know, Joseph Gens did commit perjury. You know, in terms of if he's saying now that that affidavit is untrue. You know, but it's compelling because of what I know about the case.
What's compelling?
That affidavit.
Okay.
It's compelling because of what I know about the case. It fits the fact scenario that my client has provided. And
so basically you're asking the court to completely disregard what Mr. Gens said when he testified?
I think you can take his credibility into account as to...
Believe that he killed Jane, but don't believe Bob was with him. Believe that he drove her Mercedes and dumped her body, but don't believe that Bob helped load her in the vehicle. So basically, you want me, anything that's favorable to Mr. Bashara to believe that Joe Gant said is true. Oh, and that at 7:30, he looked at the clock in the Mercedes-Benz as he was dropping her off. Those are the things you say, Judge, believe that. But the fact of the matter, that he was called over there to move boxes, and he saw in the garage a wheel that he looked like, we found out was a Rotary Club sign that the people even put up as part of their case. Don't believe that.
No, I'm asking the court to believe that. He was in the garage, without a doubt.
But he wasn't in there with Mr. Bashir.
That's right.
Okay. Go
And
ahead.
that's it. My client was not there.
All right.
And indisputably, he's at the Hard Luck Lounge. Indisputably. At 7 o'clock. So, you know, and I asked Joseph Gantz in specifically, and I have reference to it, but I asked him so Bob Bashara was there from 6 o'clock until 7:30. That's correct, it says Joseph Gantz. You know, so,
So on that alone is enough to say new trial.
you know what? On that alone, I would say so.
Okay. All right, go ahead.
The case that I was referring to is Blackson versus Rappley. I'm going to provide that to the court afterwards. There are so many areas I'd like to get into.
Let's take a 15-minute break and give my staff a little bit. I'll give you some extra time, okay?
All right, thank you.
Right.